Welcome to our channel of IGNOU Audiobooks, Indira Gandhi National Open University, School of Law, SOL, Postgraduate Diploma in Intellectual Property Rights, PGDIPR. MIP 105 Copyright and Related Rights. Block 1 Basics of Copyright. Unit 3 Ownership and Duration 3.1 Introduction. Copyright is an intellectual property right, just like patents and industrial designs. The ownership of the right is determined by certain factors. Original creation is the most important criterion. Ordinarily, authorship and ownership of copyright go hand in hand. However, these rights have lot of economic significance. Investment is a major factor in the matter of intellectual property rights. One of the objectives of intellectual property rights is to create a conducive environment for investment in endeavors that help in creation of intellectual property rights. For example, making of a cinematograph film is a cost-intensive effort. All the risk in the making of the film is with the producer. His investment needs to be protected, otherwise, there will not be enough investors. Copyright law, therefore, takes care of interests of both creators as well as the persons who invests in creativity. There are many industries which are dependent on copyrights. For example, the printing industry is highly dependent on copyrights. Cinematograph, film and sound recording industries are also very dependent on copyrights. Another industry which has keen into prominence in India recently and which is again dependent on copyrights is the software industry, since software is protected under copyright law. The media, both print and audiovisual, are also dependent on copyright since the contents which they deal with are protected by copyrights. The Indian law in certain cases gives the ownership to the producers such as cinematograph and sound recording producers, while in the case of most of the literary, dramatic and musical works the first owner is the author himself. Even in these cases also there are certain exceptions such as creation of a work as part of employment conditions. As stated earlier, copyright, like other intellectual property rights, are restricted by certain factors so that they do not become permanent monopolies which may affect adversely creation of more original works. One of the conditions binding copyright is time. These rights, like patent rights, are for limited duration. The term of protection of copyrights is, however, much longer than the term of protection of patents. This is because of the nature of the two rights. There are two arguments regarding the term of copyright. One group argues that it should be permanent like the rights in a physical property. The other group argues that it is a personal right and should terminate with the death of the author. The second group argues that the works, being part of the cultural patrimony, should move into the public domain at the earliest so that all can access it freely. The present regime is a compromise between these two viewpoints. The term of copyright also has an international ramification. While copyright in every country is dictated by the law of the country, in the case of term of a copyright, it is the country of origin, that is, where the work was created matters. If the term of protection as per the country of origin expires, then the term of protection in all other jurisdictions also expire. 3.2 Objectives. After reading this unit, you should be able to state who is the first owner of copyright in a category of work, explain the difference between authorship and ownership, and calculate the term of copyright of a work. 3.3 Ownership. Copyright is ordinarily with the author, that is, the creator. Author in relation to a literary or dramatic work is the person who creates or writes the work. In relation to a musical work, it is the composer, and in relation to an artistic work other than a photograph, it is the artist. The photographer is the author of the photograph he takes. In relation to a cinematograph film or a sound recording, it is the producer who is the author and owner of copyright. In relation to literary, dramatic, musical or artistic work which is computer generated, the person who causes the work to be created is the author. In the case of collective works like encyclopedias, anthologies, directories, etc., the copyright for the collection and editing generally vests with the editor. However, inclusion of individual pieces, if sourced from outside, has to be with the permission of the copyright owner in that work. In certain cases, individual authors while allowing inclusion of their pieces in the anthology, may retain their individual copyrights. Quote. A publisher requests an independent author to write a book which he promises to publish. In the absence of any contract to the contrary, the author and not the publisher shall be the first owner of the copyright in the book. This would be the case even if the publisher had promised some monetary payment for writing the book. If a person writes a drama for a society, but there is no contract regarding the copyright, the author is the copyright owner and not the society. There are, however, many exemptions to this general rule. For instance, there is special provision in the case of works of journalists. It says, in the case of a literary, dramatic or artistic work made by an author in the course of his employment with a newspaper, magazine or similar periodical, under a contract of service or apprenticeship, for the purpose of publication in the newspaper, magazine or similar periodical, the employer shall, in the absence of any contract to the contrary, be the first owner of the copyright so far as publication in any newspaper, magazine or similar periodical is concerned, but in all other respects, the author shall be the first owner of the copyright. This means the ownership is divided into two categories. The proprietor of the newspaper or periodical gets the right to publish it in a newspaper or periodical, and the author has the right to publish it in other places and formats. Of course, a contract can be signed between the proprietor and the employee whereby all rights can be passed on to the proprietor. Another instance where the creator may not be the first owner is in the case of a photograph taken or a painting or portrait drawn or an engraving or cinematograph film made for valuable consideration at the instance of another person. The person who paid the valuable consideration shall be the first owner. Of course, in this case also, a contract between the artist and the affancier can change the ownership. Similarly, in the case of work made during the course of employment under a contract of service or apprenticeship, the employer shall, in the absence of a contract to the contrary, be the first owner of the copyright in the work. In the case of government work and work of a public undertaking or international organization, again, in the absence of any contract to the contrary, the first owner of the copyright is the government or public undertaking or international organization, as the case may be. In the case of any address or speech delivered in public, the person who delivers the address shall be the first owner of the copyright in that speech, provided it is written down speech. However, in case the speech is delivered by a person on behalf of any other person, then the person on whose behalf the speech was delivered would be the first owner. In the case of speeches, the employee-employer relationship does not come into play. The ownership can be assigned in writing to another person. Such assignment can be done in respect of copyright not only in existing works but also in future works. Of course, in respect of future work, such assignment takes effect only when the work comes into existence. The assignments can also be in respect of all the rights or in respect of specific rights. Case law. The issue of ownership and joint authorship came up in the case of Najma Heptullah vs. Orient Longman Limited and Oz, Air 1989, Delhi 63, 1988, 2, ARBLR 302, Delhi. The first and the important question which arises for consideration in this case is as to who is the author of the book India Wins Freedom. The term author has been defined, not that the definition is of any assistance, in section 2c, as meaning, in relation to a literary or dramatic work, the author of the work. Section 55(2), however, provides that where in a literary work a name purporting to be that of an author appears on the work as published, then the person whose name so appears shall be presumed, unless the contrary is proved, to be the author of the work. In the present case, the book as published no doubt purports to show Maulana Azad as the author thereof. It is, however, contended by the defendants that, from the preface to the book, written by Prof. Humayun Kabir, as well as from the facts gathered from the preamble of the agreement dated the 2nd of September 1958, it can be proved that Maulana Azad is not the sole author. While according to defendant number 6 Prof. Humayun Kabir is the sole author, the case of Orient long ones, however, is that Maulana Azad and Prof. Humayun Kabir have, in law, to be regarded as joint authors. The book having been published after Maulana Azad's death, it has to be shown as to whether Prof. Humayun Kabir had the authority to enter into the agreement. Dated the 2nd of September 1958 with Orient Longmans. This authority had to be derived by Prof. Humayun Kabir from the legal representatives of Maulana Azad. Irrespective of the fact whether Maulana Azad was the sole or the joint author of the book, what has, however, to be seriously considered is the contention to the effect that Prof. Humayun Kabir was the sole author. My attention was drawn to the preface to the said book written by Prof. Humayun Kabir on the 15th of March 1958, in which he has referred to the background and the manner in which the said book was written. According to Prof. Kabir, on his persuasion, Maulana Azad agreed to write his autobiography on Prof. Kabir, assuring that he would do his best to relieve Maulana Azad of the actual burden of writing. About 2 years were spent on the writing of the book, and Maulana Azad used to describe his experiences and Prof. Kabir used to make copious notes. When sufficient material would be collected for a chapter, a draft in English would be prepared by Prof. Kabir and handed over to Maulana Azad. Maulana Azad then read each chapter, and then both Prof. Kabir and Maulana Azad went over the said chapter together. It is at this stage that Maulana Azad is stated to have made many amendments, additions, alterations and omissions. The first draft of the completed book was ready in September 1957 and, according to Prof. Kabir, Maulana Azad then decided that some 30 pages of the book dealing with the incidents and reflections mainly of a personal character should not be published for the present. It was Maulana Azad's direction that a copy each of the complete text should be deposited under sealed cover M, the National Library and the National Archives. After the text of 30 pages was excluded, a revised draft was prepared and was presented to Maulana Azad towards the end of November 1957. It is further mentioned by Prof. Kabir in the preface that when the final draft was ready, Maulana Azad went through the manuscript chapter by chapter and sentence by sentence and made some minor alterations. It has also been stated that there are opinions and judgments in the book with which Prof. Kabir did not agree, but since my, Prof. Kabir's, function was only to record Maulana Azad's findings, it would have been highly improper to let my views color the narrative. It has further been mentioned that it is difficult for a man to reflect with complete accuracy the views and opinions of another when expressed in a different language. Maulana Azad used to convey his thoughts in Urdu and the same were expressed in English by Prof. Humayun Kabir. The reading of the agreement dated the 2nd of September 1958, however, shows that Prof. Kabir assumed of himself the role of a composer of the book. This is an improvement, if not at variance, with what Prof. Kabir himself wrote in the preface to book on the 15th of March 1958. In the agreement, it has been made out that Maulana Azad dictated certain notes to the composer, and it is the composer who, out of the materials obtained, composed the book which was approved by Maulana Azad. Another improvement in this agreement is that it has been made out as if one half of the royalty was payable to Prof. Kabir in accordance with the wishes of Maulana Azad. At this interlocutory stage, in the absence of any other evidence on record, I will proceed on the assumption that the facts, as narrated by Prof. Kabir himself in the preface dated the 15th of March 1958 with regard to the manner in which the manuscript of the book was prepared, are correct. While relying upon what has been stated by Prof. Kabir in the preface, the submission on behalf of defendant number 6 is that the only conclusion which can be arrived at is that it was Prof. Kabir and not Maulana Azad who was the author of the said book. It was submitted that Maulana Azad merely gave the ideas in the thoughts and conversed with Prof. Kabir in Urdu, and it is in fact Prof. Kabir who wrote the manuscript in English.sh. The court then examined the decision in the case of Donahue vs. Allied Newspapers Limited, 19373 all. ER 503. That was a case where series of articles entitled Steve Donahue's Racing Secrets were published in a newspaper. Donahue, who was a well-known jockey, communicated to Mr. Felsted, a freelance journalist, his various adventures. Felsted made notes as the conversations went on and he then wrote the articles. The manuscript was then taken to Donahue, who read it over, and when he thought that some alterations were necessary or desirable, they would be noted in the margin by Mr. Felsted, and were subsequently, at times, recorded. Articles based on the original series of articles were later published in another publication and entitled, My Racing Secrets, by Steve Donahue. This publication took place at the instance of Mr. Felsted. The plaintiff then sought an injunction restraining the publication of the aforesaid work, alleging that there had been an infringement of his copyright. Justice Farwell held that the plaintiff did not have any copyright in the present case, apart altogether from what one may call merely the embellishments, which were undoubtedly supplied wholly by Mr. Felsted, the ideas of all these stories, and, in fact, the stories themselves, were supplied by the plaintiff, but, in my judgment, upon the evidence, it is plain that the particular form of language by which those stories were conveyed was the language of Mr. Felsted and not that of the plaintiff. Although many of the stories were told in the form of dialogue, and to some extent Mr. Felsted no doubt tried to reproduce the story as it was told to him by the plaintiff, nevertheless the particular form of language in which those adventures of stories were conveyed to the public was the language of Mr. Felsted, and not the language of Mr. Donahue. After examining threadbare the logic in the case of Donahue, the court held what is of paramount importance in order to declare as to who is the author of a work, is to determine in whose language is the work written. In Donahue's case, the entire material which was incorporated in the book was known to and supplied by Donahue. It is his experiences which were written by Felsted. The court did not even refer to the case of Levy A.R.D., therefore, had no occasion to consider as to whether Donahue could be regarded as a joint author. If the reasoning in Donahue's case is correct, it would mean that the material on the basis of which a literary book is written would be of no importance, while deciding as to who is the author of a book. To agree with such a proposition would lead to results which are difficult to accept. For example, it is not unknown that great scientists may not have the literary capabilities of transcribing their discoveries, theories and thoughts so as to be easily understood. If a scientist, therefore, takes the services of another person with a view to transcribe his thoughts, findings, and material in the form of a book or articles, can it mean that the author of the scientific material is not the scientist himself but the author is the person in whose language the material is expressed? In such a case, the person who transcribed the thoughts may not even be able to understand the material which is being written, but he may still have to be regarded as a sole author, if Donahue's case is accepted as correct. Surely the intention of the Copyright Act cannot be to give the status of an author only to the person in whose language the literary piece is written, while completely ignoring the person who contributed the entire material which enabled the person to show his mastery over the language. A literary work consists of matter or material or subject which is expressed in a language and is written down. Both the subject matter and the language are important. It is difficult to comprehend, or to accept, that when two people agree to produce a work where one provides the material on his own and the other expresses the same in a language which is presentable to the public, then the entire credit for such an undertaking or literary work should go to the person who has transcribed the thoughts of another. To me it appears that if there is intellectual contribution by two or more persons pursuant to a reconverted joint design to the composition of a literary work, then those persons have to be regarded as joint authors. In the present case, from what has been stated by Prof. Kabir in the preface, it is clear that there was active and close intellectual collaboration and cooperation between Maulana Azad and Prof. Humayun Kabir, which resulted in the book India Wins Freedom. There was a reconverted joint design between the two in the writing of the book. The material for the book was supplied by Maulana Azad with a clear understanding that Prof. Kabir will describe those thoughts and conversation and write the same in English language. It is not as if Maulana Azad did not know English. The preface itself shows that Maulana Azad, along with Prof. Kabir, read every word of the manuscript and made alterations, additions, omissions and corrections. It is Maulana Azad who decided as to which 30 pages of the book were not to be published, and it is he who decided as to which of his views should be contained in the book. In fact, Prof. Kabir has categorically stated that his function was only to record Maulana Azad's findings, and it would have been highly improper to let his, Prof. Kabir's, views color the narrative. Even the conduct of Prof. Kabir belies the contention that it is he who was the sole author. As already noted herein above, 50% of the royalty of the book has been paid to the legal representatives of Maulana Azad. This is an arrangement which was entered into by Prof. Kabir with Orient Longman. If Prof. Kabir had regarded himself as the sole author, then there would have been no occasion or necessity for securing payment of royalty to the legal representatives of Maulana Azad. For the aforesaid reasons, it is not possible for me to come to the conclusion that Prof. Kabir was the sole author of the aforesaid work. As at present advised, it appears to me that Maulana Azad and Prof. Kabir have to be regarded as the joint authors of the said work. Prof. Kabir was more than a mere scribe of the thoughts of Maulana Azad. Both of them actively and intellectually collaborated in the compositions of the literary work. Another case which examined the ownership of songs and music was G.P. Films Private Limited vs. Prateek Chaudhary and Oz. 2002-24, P.T. C. 392 Calcutta. This related to ownership of copyright in song and music composed and sung under a contract. The court delved deep into the issues, as could be seen from the following extracts. It is apparent from the provisions contained in the Act that so far lyrics in musical works are concerned, lyricist and composer respectively are the authors thereof, and in view of Section 17 of the Act, the first owner of the copyright of lyrics and musical works shall be the authors unless it is shown that such work was made in course of author's employment under a contract of service or apprenticeship with his employer, and there is no agreement to the contrary as regards retention of copyright. Now the plaintiff having admitted in the application that defendant numbers 3 to 5 are lyricist and composer of the disputed songs, it is for the plaintiff to prove prima facie that those works were made by defendant numbers 3 to 5 in course of their employment under a contract of service or apprenticeship under plaintiff, and that there was no agreement to the contrary as regards copyrights. In paragraph 5 of the petition, the plaintiff stated that in or about the year 1999 it commissioned defendant numbers 3 and 5 to compose Bengali non-film lyrics and music for rendition thereof by defendant number 1, and pursuant to the said request, added on consideration thereof paid by the plaintiff, the defendant numbers 3 and 5 wrote the lyrics and composed the music in respect of those two songs. In paragraph 6, the plaintiff stated that it engaged defendant number 1 to sing in or render the aforesaid two Bengali non-film musical composition or song in, commissioned the defendant number 1 to render the aforesaid number with other non-film Bengali songs. In paragraph 20, it was stated that the plaintiff duly recorded the performance rendered by defendant number 1 in terms of the arrangement by and between the plaintiff and the defendants after the petitioner had commissioned defendant numbers 3 and 5 to compose the lyrics, tune and music relating to the said songs. The verb commission, according to Oxford Advanced Learners Dictionary of Current English, 4th edition, means give somebody the job of making something. The following examples are given therein. He commissioned a statue of his wife, commissioned an artist to paint a picture. According to the Wordsworth Dictionary of English Usage, 1995 edition, the verb commission means to give an order, ESP, for a work of art, to the following example has been given therein. He was commissioned to paint the Lord Mayor's portrait. The aforesaid statements made in paragraphs 5, 6 and 20 make it abundantly clear that the case made out by the plaintiff is that it engaged those defendants for the purpose of writing, composing and singing those two songs on remuneration. In my view, the aforesaid averments make out a clear case of contract for service but not a contract of service. It may not be out of place to Mention here that Section 17 of the Act specifies the only instances wherein author, although engaged under contract for service, loses copyright. Those are the cases of taking photograph, drawing, painting or portrait, engraving in making cinematograph film. In the present case, the defendants were not engaged for any of the aforesaid jobs. In the instant case, it is not the plaintiff's case that the defendant numbers 1 and 3 to S were its employees at any point of time, and in course of such employment those songs were written, composed or sung. Under the aforesaid circumstances, in my view, no case has been made out by the plaintiff that the defendant knows 1 and 3 to 5 were his employees under a contract of service. If we apply the aforesaid test to the fact of the present case, the answer must be in affirmative, and thus no case has been made out to bring the transaction within the purview of contract of service, as mentioned in Section 17 C of the Act. Thus, even the plaintiff arguments do not suggest that there existed a case of employment of defendant numbers 1 and 3 to 5 under a contract of service. Therefore, even on the basis of arguments made in the application, no case has been made out for copyright over lyrics and musical works. The next question is whether the plaintiff has acquired any right over sound recording. As pointed out earlier, according to the provision of Section 2(d) of the Act, producer of the sound recording is the author thereof, and according to Section 17, the copyright of such sound recording vests in such producer. From the arguments made in the application, it is clear that the plaintiff paid the higher charges of the studio and made all necessary payment for recording. Those arguments make out at the most a case of financing the recording. But there is no argument in the petition indicating that the plaintiff has also taken responsibility of such recording. The learned counsel appearing on behalf of the plaintiff placed strong reliance upon the observations in Coppinger are undertaken. They also drew attention to the observations that the word undertaken implies that it is the person directly responsible for such arrangements. Particularly in the financial sense, who is the author? It may not be out of place to mention here that previously Section 9(2)(r) of 1988 English Copyright Act simply defined the author of sound recording as being the person by whom the arrangement necessary for the making of recording were undertaken. The expression producer was however introduced into the 1988 Act with effect from December 1, 1996 by the Copyright and Related Rights Regulations, 1996. In my opinion, the aforesaid observations cannot benefit the plaintiff in any way. In view of a totally different definition of producer in Section 2(o) of the Act. According to the aforesaid provision, in order to be a producer, a person must take initiative as well as responsibility of the recording. I have already indicated that all that have been stated in the application as regards right over sound recording is that plaintiff paid all the expenses of recording, including higher charges of studio and remuneration of the musician. Those arguments, in my view, will not bring the plaintiff within the purview of producer, unless in addition to the aforesaid statements, the plaintiff avers that it has also taken responsibility of such recording. The mere statement that a master tape of recording owned by the plaintiff was prepared and retained by it does not suggest that it has taken responsibility of such recording. If a person bears all the expenses for recording and keep the master tape thereof, such facts do not imply that he has also taken responsibility of the recording and thus cannot be held to be a producer. The word responsibility, appearing in Section 2(o) of the Act, in my view, does not refer to afmanshal responsibility, but means consequential legal liability for such recording. Therefore, I find substance in the contention of the learned counsel for the defendants that no statement has been made in the application avowing consequential legal liability of the recording, and as such plaintiff cannot be held to be the producer of sound recording. 3.4 Term of copyright. The Berne Convention for the Protection of Literary and Artistic Works provides for a minimum term of protection of copyrights which is until 50 years after the death of the author. India too had provided for this term until 1991 when the Period of protection was extended from life of the author plus 50 years to life of the author plus 60 years, where the first owner of copyright is a human being. At present, the Copyright Act provides for a term of protection in literary, dramatic, musical and artistic works published within the lifetime of the author until 60 years from the beginning of the calendar year next following the year in which the author dies. In case the authorship is jointly held by more than one person, the countdown starts from the year of death of the author who dies last. In the case of a literary, dramatic or musical and artistic work which is published anonymously or pseudonymously, the term of copyright is for 60 years from the year of publication. However, once the identity of the author is revealed, the term of protection will last until 60 years from the beginning of the calendar year following the year of death of the author, just like the other works. In the case of cinematograph films and sound recordings, the term of copyright is 60 years from the year of publication. Thus, the copyright in a film produced in the year 1950 would expire on the 31st of December 2011. In the case of a literary, dramatic musical work or an engraving published posthumously, copyright shall subsist for 60 years from the year of publication, until the amendments to the Copyright Act in 2012, which came into force on the 21st of June 2012. The period of protection for photographs was 60 years only without any reference to the life of the author. But the 2012 removed the difference between photographs and other artistic works in the matter of duration of protection. In the case of works in which government or public undertaking or an international organization is the first owner, the copyright subsists until 60 years from the year of publication. In all cases, the calculation of the 60 years will commence from the beginning of the calendar year following the year of publication or year of death of the author, or the last surviving author in case of joint authorship, as the case may be. That is to say, the 31st of December is the date of expiry of copyright in any work, depending on year of publication or year of death of the author. Quote, Case law. The issue of duration of the copyright of an author's literary work came up in the Allahabad High Court in the case of Newspapers Limited vs. Ratan Shankar Prasad. AIR 1977 Astronomical Units 356. This related to the copyright in the works of late Sri Jai Shankar Prasad. He was a prolific writer in Hindi. By 16th of December 1936 he had completed 24 books, on which date he entered into an agreement with the Newspapers Limited, Allahabad, a public limited company. Under the agreement it was stipulated that Newspapers Limited, at its own risk and expense, would produce and publish the 24 books mentioned in the agreement and any other book that might be written, compiled or edited by the author in question, that during the legal term of restricted copyright the publishers shall have the exclusive right of producing and publishing the works, and the author will not during the continuance of this agreement publish or permit to be published any other edition, translation, or abridgment or extract of the works, and the copyright of the works shall remain the property of the author. As a consideration of this agreement, the publisher agreed to pay to the author a royalty of 20% of the advertised retail price on all copies sold during the legal term of unrestricted copyright. Sri Jai Shankar Prasad died on 15th of November 1937, leaving behind his son Sri Ratan Shankar Prasad, who had been accepting the royalty after the death of his father for some time. Later in 1957 and 1964 he had differences with the publisher and asked them to stop publishing the works. The case came up on that. In June 1964, Sri Ratan Shankar Prasad claimed to be the absolute holder of the copyright. Later he filed a case against the Newspapers Limited. The Newspapers Limited argued that the copyright in the works of Sri Jai Shankar Prasad had expired at the end of 25 years after the death of the author as per the Copyright Act 1914. Sri Ratan Shankar Prasad argued that the term of copyright of the works of Sri Jai Shankar Prasad would be governed by the Copyright Act of 1957, which provided for a period of protection until 50 years after the death of the author. The court took the view that the period of protection for the writings of Sri Jai Shankar Prasad, who died in 1937, would be governed by the old Act. The question is whether the present case would be governed by the old Act of 1914 or by the new Act of 1957. Section 79 of the Copyright Act of 1957 is a saving. Subsection 5 of Section 79 provides, except as otherwise provided in this Act, where any person is entitled immediately before the commencement of this Act to copyright in any work or any right in such copyright or to an interest in any such right, he shall continue to be entitled to such right or interest for the period for which he would have been entitled thereto if this Act had not come into force. The saving clause also indicates that the rights and liabilities accrued and incurred under the old Act are not to be affected by the new Act. The whole question hinges upon whether the new Act of 1957 would govern the rights of the parties or access the Act of 1914. The saving Section 79 subsection 5 of the Act of 1957 leaves no room for doubt that the rights of the parties would be governed by the old Act, and if that be so, the position under the old Act is quite clear. The legal term on the date of agreement in view of the provisions of Section 5 of the Act of 1914 was only 25 years. 3.5 Summary. In this unit, we have seen that authorship and ownership of copyright could be held by different entities depending on the circumstances of creation of the work. Mostly, in independently created works, the copyright is with the author, whereas in works created as part of employment, the copyright ownership is with the employer. Also, in case of cinematograph films and sound recordings, the ownership of copyrights is with the producers. We have also seen that the normal duration of copyright in India is lifetime of the author plus 60 years post mortem. However, in cases where the ownership is not with a human entity, it is generally 60 years. Similarly, in the cases of cinematograph films and sound recordings, the term of copyright is for 60 years. Thank you for watching. We will see you in the next video with the next chapter.